Alex here with a landlord-tenant video on moving out. This is something that I get a lot of messages on, specifically with regards to viewers who have been charged for things that they claim they already took care of. Mainly it's cleaning. And I don't know how it is in all the other states, but in Nevada, there is a statute that specifically allows a landlord to retain a portion of the security deposit for cleaning. And so sorry, let me clarify, to retain a portion of the security deposit as non-refundable for cleaning. That's the key phrase right there. The landlord will return, let's just assume that everything else in the unit was perfect and that there were no other problems, which is pretty rare. Usually they'll find something to charge you on, but let's assume that it was a perfect move out and the tenant even cleaned everything up, made it look like, like when they moved in. The landlord can and will, at least if they're a corporation or have any sense of wanting to make a profit, they will retain that non-refundable portion of the deposit for cleaning, even if you've already cleaned the unit. And you can try to fight it in court, but they're going to use the statute. They're going to cite it, and they're going to say, hey, Your Honor, pursuant to this statute, this portion of the security deposit is non-refundable. The best that somebody can try for is to show that it wasn't spent on cleaning. But even if in reality the unit was cleaned so well that the landlord didn't have to clean it, they're not going to go into court and say that. They're not going to tell the court, Your Honor, they're right, we didn't clean it because it was done so well. What they'll say is, oh, we sent in maintenance workers and they cleaned it. Even though the tenant cleaned the unit, we like to still go through and clean it again just to make sure. Maybe they didn't use disinfectant, or they missed this, this, and this, and they're hoping you don't have pictures or something. It's too easy for them to get out of it, especially with that statute, because the statute allows them to retain it as non-refundable, and so they do. So what I tell people with regards to provisions that allow a landlord to retain a portion of the security deposit for anything, in Nevada happens to be cleaning, I tell people, don't put much time into that because they're going to charge you anyway. If you're going to pay for the service whether you like it or not, you may as well take advantage of it and let them do the cleaning. That doesn't necessarily mean you should just leave a massive pigsty behind, because they'll take pictures of that and they'll potentially use it as evidence to support claims that aren't true. Like they might want to claim that you've ruined the carpet or the walls, and they might take pictures of the mess and say, oh look, since they left it so messy, the court should believe us that they also did B, C, D, and E. So you should at least do like a cursory cleaning, pick up obvious crap that's all over the place. But I wouldn't say you should spend hours and hours vacuuming, mopping, sweeping, stuff like that. Pick up anything that'll show up in a camera, leave the rest, and just let them do what they're going to do anyway, which is clean it. And they're going to charge you whether you like it or not, so that way you're not going to be as irritated or as annoyed. That portion of the security deposit is non-refundable. Just accept the reality you're never going to get it back and take advantage of the purpose that it's been set aside for. With respect to anything else, for example, damage, I still tell people you should honestly just own up to it to the landlord and let them fix it, because there's a chance that you might fix it and still get charged for it. Now, when it comes to things like holes that were left behind for like nails that you put portraits up, that kind of stuff, you typically won't get charged for it. If you seal it, spackle it, whatever, typically you won't get charged for it. But say like your dog chewed holes in the carpet, I wouldn't say it's a good idea to replace the carpet, because there are a lot of viewers who've done that, and then the landlord comes in and replaces all the carpet anyway. They'll claim something like what you used didn't match, or it wasn't uniform across the unit, or like the patch that you fixed was really clean looking and the rest was really raggedy looking, and so they just decided to take all of it out and replace it all. They'll often do this with paint too. So if there's just something marking the wall that you really can't get rid of no matter how hard you try, don't spend money to paint it. Just give in. Just tell yourself, you know what? This is just going to get repainted. There's nothing I can do to guarantee that I won't be charged. So you may as well not do it for them. And then, because what frustrates people is that they go through all the work. Some people even spend money on it, and then they get charged for it anyway. So what I've started to do is I'll just own up to it on a move out. I'll say, hey, we cleaned it, not to the best of our ability, but enough that there wasn't anything obvious. We know that the cleaning portion of the security deposit is non-refundable, so of course you're gonna, clean it anyway and charge us. So just letting you know that we didn't mop or sweep on purpose. It was on purpose that we did that, and that way that they're on notice in case they try to use it in court. And if they try to make you look bad, you could say, Your Honor, pursuant to the statute, it's non-refundable. So I was going to do something that they were just going to come back and do again after me and charge me for it. Same thing with regards to damages. Let them know, send them a notice, tell them, hey, my pet's chewed up this carpet, it's really messed up. And so we were gonna, we thought about replacing it, but in all actuality, you probably are gonna want to choose the carpet that you replace it with, and you probably have vendors. So we're just owning up to it, and take it out of the deposit because that's what it's for. So let them know ahead of time. So if they try to bring it up in court and make you look bad, you can say, hey, I told them ahead of time, and they could use the money, from the deposit to fix the damage. That's what deposit money's for. Now, if it's in excess of the deposit, be prepared to pay. But I'm just talking about situations where the damages are covered by the deposit. So it's really, it's a lesson in avoiding frustration and just assuming the worst, because you really never know what a landlord's going to do. And so this idea of fairness, that you're going to go above and beyond, you're going to spend all this money to fix the unit, and it might seem like you're going to stand out as a tenant, and they're going to think, that's great, we're going to give you more of your money back. But most of the time, that's not what happens. Most of the time, they don't want to give the money back. And so to avoid any frustration, it ends up being one of those situations where you just let them deal with the aftermath, because they're going to most likely do it anyway, and you're going to pour money into something and get charged for it anyway. So that's the approach that I try to tell people, really works when it comes to moving out. Of course, if they really just invent random things that didn't need to be fixed, you're going to have to fight that in court. There's nothing you can do about the really, really unscrupulous landlords. But a lot of the just run-of-the-mill, ordinary, especially corporate landlords, the ones that are, giant apartment complexes. It's not just like a single individual that you're renting a house from, but like a company, corporation, LLC. Those especially, they don't have this attitude of, they're going to get revenge on you, and they typically don't, no hard feelings is their approach. They'll approach you, they'll say, no hard feelings, but we did all this stuff, even though you already did it, and here's your bill, and you're just getting it $50 back. It's just how that's just how the business works, at least in Nevada and in a lot of other places. So, number one, if there is a statute that entitles them to a non-refundable portion of a deposit, just straight out of the gate, do not think you're going to get that back. And just let them do whatever it is that that portion of the money's for. And number two, even if there isn't a statute, think good and hard before you go about making repairs that you're going to put serious money into, because there is a chance, a pretty big chance, that they're going to come back behind you, and whatever you fixed, they're going to work over it anyway and charge you for it anyway. And the carpet and walls are two of those big areas. People try and do, sometimes people will do a great job painting the walls, and then the landlord will say, well, pursuant to the lease, you weren't allowed to do that. And then they'll charge you to put it back. Even if you get the color really close, they'll say, oh no, it's slightly off, and all these units have to be exactly the same. Or they'll find something to nitpick at with the work that you've done, just so that they can come behind you, do it again, and charge you for it. So I'm not going to deal with anything else in this video, for example, with regards to like proving, that you have done, certain things in court or anything like that. I'll probably cover stuff like that in my other videos, specifically my legal nuts and bolts videos. I just wanted to deal with this one specific topic in this landlord-tenant video. And if anyone has any questions, definitely go ahead and post them in the comments below or send me a message. And I will see you guys next time.